Thank you, counsel. Did Mr. Cottiel say anything this morning with which you disagree?
No, I think we cleared up any maybe potential disagreement about licensing fees, but I think we all agree on that.
Okay. Justice Thomas? Anything further? Justice King?
Briefly.
Justice Gorsuch?
Chief. So I just want to follow up on Justice Sotomayor's question at the end of a long afternoon. It does seem to me, and tell me if I'm wrong, that a really key part of the context here, if not the dispositive one for you, is the constitutional assignment of the taxing power to Congress. The power to reach into the pockets of the American people is just different, and it's been different since the founding and the Navigation Acts that were part of the spark of the American Revolution, where Parliament asserted the power to tax, to regulate commerce. Some of those were revenue raising, some of them didn't raise a lot of revenue. We had a lot of pirates in America at the time. And Americans thought even Parliament couldn't do that had to be done locally through our elected representatives. Isn't that really the major questions, non-delegation, whatever you want to describe it, isn't that what's really animating your argument today?
I think it's a huge piece of what's animating our argument. Thank you.
A Synopsis of Constitutional Law by Redlich 2002, Chapter 4, Federalism and State Regulatory Power. Examining the complex balance of power between the federal government and the states, grounded in the bedrock principle of federal supremacy, which dictates that states cannot impede, burden, or directly tax lawful national operations, while states retain the ability to cooperate horizontally through interstate compacts. Their regulatory authority is heavily restricted by the Dormant Commerce Clause to prevent economic balkanization. Under this framework, states are prohibited from enacting discriminatory or protectionist laws that unfairly burden out-of-state competitors, though they maintain the police power to enforce legitimate local health and safety measures, such as quarantines. When a state enacts a facially neutral statute that impacts interstate trade, courts apply the Pike balancing test to ensure the law effectuates legitimate local public interest without placing an excessive or unjustified burden on interstate commerce. We begin with Section 1, Federal Supremacy. Federal supremacy, the supremacy of the U.S. Constitution. I quote, "This great principle is that the Constitution and the laws made in pursuance thereof are supreme, that they control the Constitution and laws of the respective states, and cannot be controlled by them." End quote. Conflictual federalism. The McCulloch case, I quote, illustrates that in a federal system, inevitably cases arise which pit the conflicting powers of the government of the Union and its members, end quote. This limits state power. States cannot impede or burden or control the lawful powers of the national government. Section 2, Federal Regulatory Immunity. Federal officers can invoke Supremacy Clause immunity if they were performing a lawful duty originating from the Ohio v. Thompson 1899 case and the Arizona v. California 1931 case. Federal immunity is not absolute. I quote, Holmes suggested a federal employee does not secure a general immunity from state law while acting in the course of his employment, end quote. Section 3. Intergovernmental tax immunities, federal immunity. I quote, in United States versus New Mexico, the court held that private contractors managing government atomic laboratories were not exempt from New Mexico taxes on gross receipts, sales, and use, end quote. However, a state cannot directly tax the United States. If the power to tax involves the power to destroy, to permit the states to tax federal agencies would empower them to nullify federal operations, according to Redlich. Federal government is immune from direct state taxation. Section 4. Horizontal cooperation. The Compact Clause is limited only to such state compacts which intend and in reality do increase state power. If an interstate compact increases state political power at the detriment of federal supremacy, citing Virginia versus Tennessee case, it requires congressional consent. I quote, "The Constitution itself clearly contemplates cooperative action among the states in the Compact Clause," end quote. Section 5, State Regulation of Commerce, the Dormant Commerce Clause. I quote, "The framers granted Congress plenary authority over interstate commerce in the conviction that, in order to succeed, the new union would have to avoid the tendencies toward economic balkanization that had plagued relations among the colonies and later among the states under the Articles of Confederation." End quote. Railroad rates, a transportation case. A state could not dictate interstate rate regulations. In, I quote, Wabash versus Illinois, 1886, the court considered the validity of a state statute regulating railroad rates for transportation whose origin or destination was beyond the state. The court relied on Cooley to strike down the state law. Interstate rate regulation required uniformity, which must come from Washington. End quote. Section 6. Protectionism. State power to regulate public health pertaining to commerce. I quote, "Under their quarantine power, the states may enact laws designed to exclude diseased livestock or other articles which may harm public health." End quote. Section 7. Discriminatory laws. I quote, "We consider a so-called flow control ordinance, which requires all solid waste to be processed at a designated transfer station before leaving the municipality, because it attains this goal by depriving competitors, including out-of-state firms, of access to a local market. We hold that the flow control ordinance violates the Commerce Clause." End quote. The local ordinance has immediate local focus, which is good. However, its broader effect, its economic effect, is interstate in reach. Hence, unconstitutional, as it is a power belonging to Congress. With respect to this stream of commerce, the flow control ordinance discriminates, for it allows only the favored operator to process waste that is within the limits of the town, according to Redlich. States' power to regulate public health is not permission to do whatever. States cannot unjustly erect economic barriers to discriminate against out-of-state commerce and competition. Example of a legitimate health measure by a state is of Florida. In, I quote, Sly versus Cookwood, 1915, the court upheld a Florida law banning shipment out of state of any citrus fruits which were immature or unfit for consumption. Since unfit for consumption, the fruit involved could be subject to a quarantine-type measure forbidding export as harmful to public health. End quote. Section 8. facially neutral statutes. A state must find an equitable and fair solution to both in and out of state interest in that state, under the Commerce Clause. I quote, in Pike v. Bruce Church, Incorporated, 1970, the court articulated a balancing test, where the statute regulates even-handedly to effectuate a legitimate local public interest, and its effects on interstate commerce are only incidental.